Please be seated. Good afternoon, everyone. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Are the parties ready for the jury? Yes, sir. Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect the jury's back in the courtroom. Welcome back, folks. I hope you had a good lunch. All right. Right before the break, Mr. King finished his direct examination of Dr. Hanlon. Doctor, I remind you that you're still under oath. And Mr. Brockler, you may proceed with your cross-examination.
Thank you, Your Honor. Doctor, I want to talk to you a lot about what Mr. King was able to elicit from you, but before I do that, I really want us to focus on the purpose that you are hired to serve as well as the scope of your opinion. Can we do that?
Certainly.
Now, you were asked to do a neuropsychological evaluation of the defendant in April 2013. Is that fair?
Yes.
And that is some 8 months or so after the shooting at the theater and the bombs in the apartment and all that stuff. Fair? It could be 9 months.
Yeah, a little longer than that.
Okay, is that right that you did
Yes,
that?
that is right.
And then you were asked to do another neuropsychological evaluation, not completely different from the one you did in April of 2013, in January of 2015. Fair?
Yes.
You have provided no opinion on sanity, correct?
True.
And that's not just true for July 19th or 20th. You didn't offer up an opinion for sanity for any time period. Fair?
That's right.
And your opinions are based upon just those snapshots of testing, in large part, that you've taken from April of 2013 and January of 2015, and then some information you reviewed in between. Is that fair?
Yes.
You did not go back and review the conduct of the defendant as it existed leading up to July 19th and 20th.
True.
Now, one of the and so that I'm clear, you're not here to tell this jury that you can give them an opinion about this man's capacity to form the intent to murder after deliberation on July 19th and 20th, 2012.
I am not.
And you're not here to provide them any information on the defendant's capacity to know right from wrong based on societal standards of morality back on July 19th or 20th, 2012, correct?
I am not.
And you can't provide them, and you don't provide them, with an opinion on even his capacity to have done those two things as of January of 2015.
True.
Really, it's limited to an exploration of what potentially could be a mental illness that exists between April of 2013 and January of 2015. Is that fair?
Yes.
Now, one of the things that Mr. King started off by asking you was, hey, look, weren't you largely and completely independent in the way in which you were able to conduct this neuropsychological evaluation? Do you remember that?
Yes.
And that there were no limitations imposed upon you in terms of how you went about that neuropsychological evaluation?
Objection, Judge. That misstates the testimony.
Overruled.
But I guess I'll ask you an open-ended question. Were limitations placed on your neuropsychological evaluation of the defendant in April 2013?
There were no limitations placed on me by any other sources. I was asked to conduct a neuropsychological evaluation. I defined what that neuropsychological evaluation would consist of, and that's how I proceeded.
And if there were any additional documents, records, or information you believed you needed to be thorough in this investigation, heck, you'd ask for them, wouldn't you?
I would have.
And if they hadn't provided them to you, as you said to us in direct, I would not have conducted the evaluation and you said to Mr. King, had you limited me. Is that fair?
True.
The reason I ask is, and I want to ask about this, is look, the person that hires you and pays you, they tell you what they want to accomplish, right? And I mean by neuropsychological evaluation. I'm not talking outcome. I'm saying neuropsychological evaluation. They tell you what they want, right?
Right. He told me he wanted a neuropsychological evaluation.
You routinely write reports whenever you do a neuropsychological evaluation.
Yes.
There really aren't any good reasons to not write reports after you do a neuropsychological evaluation, right?
Well, let me qualify that. There are times when I do a neuropsychological evaluation and I am then asked not to produce a report.
Whoa. Well, but you won't let yourself be limited in how you do it and how you... Would you, if someone told you don't write a report, you'd say, I got to write a report. This is how I do my neuropsychological evaluation. This is how I document it. Would you do that, or would you do what they asked you to do?
No. If I will conduct the evaluation as I see fit. If I am then asked not to produce a report, I will honor that request.
And you know that the report serves some pretty important functions in this system, correct?
I do.
Those reports, one, are going to be weighed and considered by the very people that picked you out and hired you, right?
Yes.
They're also going to be considered by the other side, which in every single criminal case you've ever handled has been the prosecution, correct?
Yes.
And the prosecution is going to make decisions about it. The judge, this court, maybe even this jury are all going to rely upon that report in some way, don't you think?
Probably.
So to not generate a report is to deprive the other members of the system that information. Fair?
Fair.
All right, and that's the reason I ask is, and we'll get to what happened here in this case, but that's exactly what you did in a case called People versus Wood out in, I think it was Illinois. Do you remember that? You testified in that case, and you did not generate a report. Do you remember that?
Objection, relevance.
Your Honor.
Why don't you approach
Yeah.
it?
Yes, that's better.
All right, the objection is overruled.
Doctor, I'll be candid, I don't remember the exact question. Do you remember it? Well,
I don't remember the exact question. I think it had to do with why I didn't produce a report.
Yeah, let me just, if I've already asked this particular question, forgive me, but what I want to get to is this. Look, you've said that you think generating reports are important, and you've described for us or agreed to why they're important in the system, correct?
Yes.
And you also agreed that you would withhold writing such an important report if you were asked by the people that hired you to not generate a report. Fair?
True.
And in fact, you did that in another, I think it was a murder case, People versus Wood, correct?
Right.
Now,
Can I add something to that?
on redirect, Mr. King can follow up on all of this stuff. Is that fair?
Sure.
There was something else I wanted to ask you about, though. So in terms of conducting this neuropsychological evaluation, you described for us through Mr. King how broadly that was defined, just go out and do a neuropsychological evaluation. One of the things that you think is important is to interview other family members about the person you're doing the neuropsychological evaluation on. True?
Yes.
And you think it's important to do that to obtain as much information from as many sources as possible, correct?
True.
And you want to get input from individuals and significant others who know the defendant very well, correct?
Yes.
And you did not do that in this case, correct?
True.
And you didn't do it in this case not because you didn't want to, right?
True.
You asked them to let you interview them, and they did not. Fair?
True.
To be clear, being denied access to information you asked for did not cause you to say, that's it, I don't want to play anymore, right?
True.
In fact, even in this particular case, you said you conducted 2 evaluations, and we've talked about the dates. You remember that?
Yes.
There are subjects that you inquired about with the defendant in January of 2015 that you did not inquire about in April of 2013. Is that fair?
Yes.
And the specific reason that you inquired of those areas of the defendant 2 weeks before the trial started was because Mr. King told you to. Fair?
He asked me to.
And you did it.
I did.
And then wrote it in your report.
True.
In terms of this particular, we'll take these in order. The first time you meet with the defendant is April, is it 8th, sir, of 2013?
I think it's 18th.
18th, thank you, April 18th. And before you do any testing, you sit down and you go through with him a bunch of questions, don't you?
Yes.
Now look, before you did that, before you sat down to ask him questions, had you already gone through the materials that the public defender's office was willing to give you?
Yes.
And if they don't give you the records, you don't know that they exist, correct?
Yes.
I want to go through some of the records that you received here. You talked a little bit about them with Mr. King. You went through really just his transcripts from middle school, high school, University of California, Riverside, and Anschutz, the grad school. Is that fair?
Looking at refer to my report.
Yes. Absolutely. Every time, you may do it any time you want, as long as you just tell us what you're referring to.
Okay. Thank you.
Mr. Brockwood?
Yes, sir?
I think he's ready.
Oh, I'm sorry. Yeah, I'm sorry. Yes, sir.
Is there I think you have a question. There's a question on the table.
There was. It was about, and I'm looking, I can't remember what page it is. I'm looking at the records you reviewed for your very first evaluation, the records you reviewed before you sat down with the defendant. Do you remember that?
Yes.
And I went through the academic ones, and it looks like you reviewed the transcripts from these things, correct?
Correct.
One of the things that, when it says academic records of James Holmes from the University of Colorado, Denver, one of the things you did not do was you didn't review his assignments that he was turning in between August of 2011 and May of 2012, correct?
True.
One of the things, though, that you did consider were 2 letters that he wrote to college to get admitted into college. Do you remember that? Now, you don't list them here, but you refer to them elsewhere. Specifically, later on, it's a paragraph that begins, "in a college application form." Do you remember that? And you can, I wish I could tell you which page.
Okay. Yes, I see. Page 3.
Okay. So you make reference, in fact, you quote 2 letters that he wrote to colleges to gain admission, correct?
I do.
And you remember what you had told us about that was you considered those letters because you wanted to know what his fluency was, his ability to write, his sort of grasp of English and communicate, that sort of stuff, right?
True.
And you took those 2 samples from, well, do you remember when the letters were submitted? Do you know if they were to grad school or undergrad? That would help. Let's just presume closer in time. Let's say they were submitted. Go ahead.
I'm sorry. They are to UC, University of California.
Oh, they were letters he submitted then back in 2006?
Yes.
And that was important to consider to know his fluency and ability to write, all that stuff, communicate. Fair?
Yes.
Now, one of the things that exists here in this case in discovery are papers that he wrote and submitted in grad school in the months leading up to this crime. Are you aware of that?
I am.
You were not
Now.
provided those. Oh, hold on. You did not know that before I said it right here?
I did not have them at the time that I
So
evaluated him and wrote the report.
Sorry, the defense
Sorry.
did not provide you with those written materials for you to consider.
True.
There are also, and we've seen them, a cajillion emails from multiple email accounts that span the months leading up to this crime. Were you aware of that?
I am.
Did you review those?
Not prior to my original evaluation.
How about the text messages that he was sending, and there's something called G-chats, Google chats?
No.
Had you been provided all that stuff before your evaluation and then decided, I'm not going to consider it?
Judge, I'm going to object. A lack of foundation. These materials were not available at that time, I don't believe.
All right, the objection is overruled.
Had you been provided those materials, doctor, before your evaluation?
I don't believe so.
Now, you suggested that at some point you did review them all. Is that fair?
Eventually, I reviewed some of those records.
Well, eventually, as in when?
Sometime between my first evaluation and second evaluation. I'm sorry, I can't be more specific.
That's okay. But to be clear, your first evaluation was done in the absence of these materials, fair?
Correct.
And your second evaluation included a sampling of these materials. Is that fair?
Yes.
When you say sampling, because you adopted my word, thank you, how many? And over what period of time? Can you tell us?
I certainly did not review all of those records. I would say maybe a third.
A third?
Of those records.
Did you review his submissions to the mock grant writing proposal class that earned him an A?
No.
There are other things that you might have had the opportunity to review prior to your evaluation of the defendant. And they include videos of him communicating with people right before and right after the event. Are you aware of the existence of those videos? And I'm not talking about Dr. Reed's now. That's way after.
Right. Can you help orient me by telling me who they were to?
There were videos of the defendant, let's say in the May-June time frame from school in a presentation, and then audio and video of the defendant immediately after the crime and in speaking with the now absent Detective Apple and Special Agent Gumbener.
I have not reviewed the videos prior to the crime.
Is that because you were not provided them, or you have them and you just didn't think them relevant?
I don't know if I was provided with those or not.
Okay. Something else is that you then list on the records that you reviewed before your April 2013 interview with the defendant are records from Doctors Fenton and from Margaret Roth, correct? Do you see that in your report, sir? Right below the academic stuff.
I see Dr. Fenton.
It's the one below.
Yes,
Fenton.
I see it. I'm sorry.
Yeah.
Yes.
Okay. You also reviewed records of the defendant from the Arapahoe County Sheriff's Office, correct?
Yes.
From the detention facility, correct?
Yes.
And from Denver Mental Health, correct?
Yes.
The records I do not see listed here, but perhaps you considered them were the kites that the defendant submitted during his 4 months between his arrest and his trip to Denver Mental Health. Did you have those to review?
Not that I'm aware of.
Those would also be communications of him to someone else right after the crime, correct? As far as you know?
That's my understanding.
All right. Also, something I don't see in there are the 14 pages of handwritten notes by someone named Jonathan Woodcock. You didn't have those to consider.
I don't believe so.
They were not given to you by the defense, fair?
Apparently not.
Because you would, I mean, look, if a psychiatrist had sat down and talked with this guy on July 24th, 4 days after this, you would have wanted to see what that person says, correct?
I would.
And you didn't have it, right?
I don't believe so.
All right, so you sat down with him. You talked about the actually, you know what? I want to reference you to one of the things that you highlighted in your report about one of those essays that the defendant submitted apparently back in 2006 or something like that. You see that passage?
Yes, two of them.
One of the things that he says is, I'm a defender in soccer where I'm determined to stop the other team from scoring. To do this, I must anticipate the other team's tactics. Knowing what needs to be achieved and then pursuing that target is purpose, correct?
Yes.
And that's a passage you picked to include in there, right?
Yes.
You also included, there's a lot of your report, Doctor, and if you think I'm overstating this, you let me know. There's a lot of your report that is you taking things out of other records and other people's reports, putting quotes around them, and then sticking them in there to sort of build a chronology. Is that accurate?
That's accurate.
That's like pages of your report. Is that fair?
It's a few pages.
Okay. And one of the things that you have on there is you have some of the dates that he went and saw Doctors Fenton and then Feinstein, correct? I'm talking now about the April, June-ish 2012 entries, fair?
Yes.
But you have a big jump between April and June, right? You don't put down his meetings with Fenton or Feinstein in May, correct?
True.
When you reviewed those records, one of the things that came up in the discussion with Drs. Fenton and Feinstein was and you put this in your report, is the defendant's hatred of humans, correct?
Yes, it is.
Now, to be clear, you did not follow up on that, right? With him.
Or directly with him? No, I did not.
Indirectly with him?
No, I did not.
Okay. And part of that is because you just didn't see that as the purpose you were asked to fulfill by the defense attorneys, correct?
That's true.
All right. And that would mean, too, then, that you didn't review anything about his written word or his thoughts in the notebook prior to interviewing him, right?
That's true.
Judge, I'm going to object. The notebook was not available at that point in time to anyone. And
I think you asked him about that too, if I remember correctly.
I did, and he said it wasn't available.
Okay, well, so the objection is overruled. You asked it, Mr. Bruckler's on cross-examination, he can ask it too.
There's an interview that was done with Detective Apple and Governor. Just to follow up, did you listen to that interview before you interviewed the defendant? Or right after the crime, where he goes into the details of the bombs in his apartment?
No.
you do ask him, or did you ask him about like what he was doing and what he was reading in that session? Did you do that?
What he was reading at the time that I conducted the evaluation?
Yes, sir. Yeah.
No, not in the first evaluation.
That must have been something you took out of another report where he indicates he's reading science fiction. Does that sound right?
I documented what he told me he had been reading in the second evaluation.
Oh, okay. We'll get to that. We'll get to that. Not in the first, right?
Right.
So the other thing I notice about your report when you're doing this chronology is you jump from roughly July 26th to November 11th, which is what begins this Denver mental health stuff, correct?
Yes.
In between, what you don't document is the reference made in the jail reports to him disassembling a handicap bar in his cell to use as a club. You don't document that. Do you recall that?
I don't recall it.
How about, did you document or do you recall him trying to get behind an electrical plate in his cell using some manufactured tool or something? Do you remember that?
I don't recall that.
Was that not provided to you?
I would think I would recall it if I had read it.
Okay. Then finally you start talking with him and you start going through things like demographics, correct?
Yes.
And you start going through his medical history with him, right?
Yes.
And one of the things that comes out in his medical history is he says to you that he has been depressed for the past 1.5 years, correct?
Yes.
And that would date back to about October of 2011. And take a moment to do the math, I had to.
Yes.
Right? That would put him right at about the beginning of his one and only love relationship with his girlfriend. Is that fair?
Objection, beyond the scope.
Overruled?
Go ahead, sir.
I think so, more or less. I don't recall exactly the time frame on that.
Forgive me, I didn't even ask you the leading question. Did you know that he'd had a first in his life girlfriend and sexual experience in the months leading up to this crime?
Objection, beyond the scope, relevance.
Overruled?
Go ahead, sir.
I did not know that at the time of the first evaluation.
Okay, now that you know it, though, would you agree that this 1.5 years, I've been depressed for 1.5 years, puts him back to the very beginning of that relationship?
I think so.
Okay. There's also a discussion of his psychiatric history. Do you recall that?
Yes.
And again, he restates to you depression for 1.5 years, right?
True.
Interestingly, what you discovered in reviewing all the records leading up to this is that he never tells anyone, mental health professionals included, that he's depressed. Would you agree with that?
I don't recall him expressing depressed mood to mental health professionals.
And you don't recall any of them saying, despite him not saying it, he looks depressed. You don't recall that either.
True, I don't recall that.
Okay. He also says, you ask him for the psychiatric history, you say, why did you go start seeing Dr. Fenton? Or a question like that. Do you see that? April 2012?
Yes.
And what he tells you is, the defendant tells you, I was nervous about speaking, about public speaking, correct?
Right.
He does not ever tell you, because you would have put it in your report, that he went to see them to rid himself of homicidal thoughts, correct?
True.
In fact, he also tells you that, look, at one point, Dr. Feinstein wants to prescribe an antipsychotic, and I didn't do it.
Right.
He says, I didn't do it because I left treatment, right?
Right.
And he says he left treatment, or he didn't do it because his insurance wouldn't cover it, correct?
Right.
He does not tell you that those two doctors offered to treat him continuously for free after that, did he?
He did not.
He talks about a time when he is age 8 and he goes for some sort of treatment or therapy. Do you recall that?
Yes.
Were you provided records from the public defender's office about that treatment? You recall? Salinas family, something, something?
I believe I was eventually provided with those records.
How about prior to your interview of the defendant for this neuropsychological evaluation?
If I didn't document it in my record list, then I didn't.
Okay. And he tells you that at age 8, he saw a psychiatrist, he was really a therapist, but a psychiatrist in Claremont, California one time, correct?
Right.
Does that jive with the records that you got from the Salinas family something?
Judge, I'm going to object. May we approach?
Yes. The objection is overruled. Yes?
Again, doctor, forgive me, the delay was limiting for me. Do you remember the last question?
I don't.
If I go by the little hash marks on my paper here, what I think I was asking you about was the Salinas family, whatever the rest of the words were when he was 8 years old. Do you remember that?
Yes.
Okay, and one of the questions that I asked you was if you ever took his statements about that visit, and he described it to you as a one-time visit to a psychiatrist in Claremont, California, and compared it at all with the records that you had been provided from the Salinas family, I'll call it center. Did you do that?
I don't believe so.
One of the things when he's describing that 8-year-old trip that he says to you, well, first off, he doesn't say to you, I don't remember what that was about, correct?
True.
He doesn't say it was because he hit his sister, right?
He does not.
He doesn't say anything about barricading himself in his room, correct?
True.
What he says to you is, this is a quote, I was screaming, but I wouldn't talk. Correct?
Correct.
All right. No other follow-up on that. Fair?
True.
And you certainly made no efforts to reach out to whether it was Claremont, Salinas, any other place. Fair?
Yes.
Okay. Then he tells you that he attempted suicide at age 13. You see that?
Yes.
Did he use the word suicide, parasuicide, or just describe the action and you gave it its conclusion? I ask because it's not in quotes, so. Yes, sir?
Can I look at my notes?
Every time. You just tell us what you're looking at.
Mr. Brockler, from my
Yes,
notes, he gave, as I documented in my report, the quote, I think he alluded to the idea that it was a suicide attempt. He quoted, or he stated, I saw it on my wrists. I don't know if suicide was his term or my term. I don't have it in quotes.
Okay, and you don't have it in your notes as something he said?
Right? I have suicide attempt underlined.
All right.
And 13-year-old, quote, saw it on wrists, unquote.
Did you ask him, by the way, did you follow up and ask him what you saw on your wrists with?
I didn't.
Okay. What he doesn't tell you, though, is that, hey, everybody knew I did that. He didn't tell you that?
No.
He didn't tell you it was something that he kept from everybody? No?
No.
He didn't tell you that because of that and his family's awareness of it, he was taken to seek additional counseling through someone named Mel Lipsy, right?
He didn't connect the two incidents to me with regard to the seeing of Mel Lipsy.
Well, in part, it's because you have down that he told you it was 3 years later, when he was 16, that they went and saw Mel Lipsy, correct?
Right.
All right, so there's no connection that you were told of, are aware of, or have seen in any document you've been provided that you're aware of between him sawing on his wrists, and I've just used air quotes, and the therapy session with Mel Lipsy, correct?
True.
Okay. When you observe him, you make these observations, that he's consistently alert, responsive, and oriented to person, place, and time. Fair?
Yes.
That his speech rate, tone, and volume were within normal limits.
Correct.
That his eye contact and conversational turn-taking were within normal limits. Correct?
Yes.
What you never observed was him having some wide fluctuation of emotional responses. Correct?
True.
You never see him make facial expressions like he was crying without making noises, right?
No.
You never see him with his mouth open, gaping wide open, seemingly emotional about something, anything.
No.
And during these topics that you have chosen to ask about it, I presume you picked the ones you thought that were going to be most helpful to you understanding his neuropsychological state, correct?
Yes.
There are 3 areas you absolutely do not go into with him, including you don't ask him about human capital or his beliefs regarding that, correct?
No.
You don't ask him about his views or thoughts on any potential outcome of the case, correct?
No.
You don't ask him or go into any issues of regret, remorse, or anything like that, correct?
No.
Because those were not relevant to your neuropsychological evaluation, correct?
True.
All right. And to be clear, you did ask about those some 20, wait a minute. How many months after April was the January thing you did with him, doctor?
20 months.
20 months. Some 20 months later, when you redid the psychological evaluation, those were the 3 areas you were asked to get into with the defendant by Mr. King. Fair?
True.
And you did it.
I did.
And when he gave you whatever answers he gave you, you did not follow up on them. You just wrote them in your report, correct?
Yes.
Because that's what you were asked to do.
Yes.
All right. Now, let's talk about these tests. I heard the detail that you gave through this, and sort of the reason I wanted to ask you about the statements that the defendant had made to you during these different parts of the clinical interview, is that the right phrase? Clinical interview?
Yes.
That you conducted, was because there'd been a lot of discussion about these validity tests, malingering tests. Do you remember all that?
Yes.
And the words that you and Mr. King used were, hey, he'd passed them. There was like 40 of them. He passed them all, correct?
Yes.
But let's be clear, though, about what the malingering and validity tests do. Those tests test his effort on those tests, correct?
Yes.
They are meant to determine whether he's malingering on those tests, correct?
Yes.
And what they don't do for us is they don't give us some sort of guarantee that the defendant is being honest or accurate or forthcoming with us in our face-to-face interviews with him, correct?
True.
One of the tests that you did not give was one you talked about called the SIRS-2. Do you remember that?
Yes.
You described that as an incredibly sensitive, skilled test at determining whether or not someone was feigning psychiatric symptoms. Do you remember that?
Judge,
Yes.
may we approach?
Yes. right, thanks for your patience, folks. Mr. Broccoli, you may proceed based on the discussion we had at the bench.
Thank you, Judge. Doctor, the last thing that we had talked about was my description based on what I thought you had said about the SIRS-2 being this very sensitive test for malingering psychiatric symptoms. Do you recall that?
Yes.
And one of the things that you had written at a prior time in a book chapter was that on a different case where you hadn't administered it was even in cases where you don't necessarily think it's completely appropriate, you think it ought to be given. Fair?
I said something to that extent.
Yeah, and in this particular case, you did not administer the SIRS-2 in April of 2013. Fair?
True.
By the time it's ultimately administered to the defendant in July of 2014, you'd agree with me that the defendant has been exposed to a lot of psychological and psychiatric testing. Fair?
Yes.
Not just yours, correct?
Right.
But Dr. Gray's, right?
Right.
Dr. Manguso, yes?
Right.
Dr. Metzner, yes?
Yes.
Dr. Gurr.
Right.
And in addition to all the tests associated with all of those, you had a concern about the SIRS being given when someone had had the opportunity to sit in and listen to sort of a detailed discussion about its uses and how it works. Is that fair?
You're referring to the hearing, right?
Yes, sir?
Yes.
And yet that happened. Even before July of 2014, the defendant was able to sit and hear this discussion about the SIRS-2, correct?
You did.
And that caused you concern about whether or not that might actually impact the validity of it.
I did. It did.
Okay. There's the bunch of tests that you referred to that you administered to the defendant back in 2013. Here's words that I see for almost every single thing, and you stop me if I'm misstating this. For auditory, average range, intact. Fair? Under attention, sir. Sorry.
Yes.
And when we talk average, what we've heard before, and I think you were present here in the courtroom with Dr. Manguso, was that that's not average for the planet Earth. That's average normed to guys like the defendant, right? In many cases, white men with 16 to 17 years of education. Is that fair?
Yes, depending on the specific test and how that test is normed, yes, it may be age, gender, education, or it may just be age, or it may be education and age, but yes, those are the factors.
And so in many of these cases where we see that the defendant is performing at the average, above average, or even slightly below average range, in these cases where we're not talking about someone who's post-undergraduate degree, would you let us know that as we go through them?
Sure.
Okay. On the visual stuff, and I don't want to go through every test, but I'm reading the words that I see in your paragraphs. Within normal limits, average range, average range, average range. Sound right?
Yes.
Auditory verbal, I see low average range, intact, average range, intact, high average range, and then something where it says 100% accuracy on the forced choice recognition subtest of the CVLT2. Is that just a validity thing too, to show that he's just putting forth effort?
Yes.
Got it. Visual nonverbal, superior range, average range. Does that sound right?
Yes.
I'm boring myself here by going through this. Let me just ask you for the 2000, no offense to the work product, I just know that we've gone through this with Mr. King. All right. But is it fair to say that by the end of the 2013 testing, what you've concluded is, look, this guy is either average or intact, and you describe that term for us, in terms of all these things that you tested. Fair?
Yes.
And then one of the things that you talked about was testing the executive functions, reasoning and executive functions, right?
Yes.
And those are our highest order of brain stuff. Yep. Right? Thinking.
That's one way to put it, yes.
Yeah. What words would you use? Highest order what?
They are high-order human cognitive functions.
Human cognitive functions. Great. And he is doing very well in that, right?
Yes.
In fact, you say his performance reflected a preserved capacity for formulating alternative solutions to novel problems and shifting cognitive set in response to changing task demands. Is that fair?
I did.
That's a lot of words, but it says he's doing real well, correct?
It does.
And those executive functions control things like your ability to plan, right?
Yes.
To problem solve, right?
Yes.
To deliberate on issues and figure out how to achieve them.
Yes.
And in fact, it also talks about your ability to shift to a changing environment, kind of shift on the fly, as we heard with Dr. Manguso. You'd agree with that?
Yes.
There's other stuff that you did with him, though, that we didn't get into details on. There's something called the IGT. What's the IGT test?
The IGT?
Did I say it wrong?
I thought you said DT. The IGT.
Yes, sir.
Yes. That's an acronym for the Iowa Gambling Task.
Okay, and what's important about that is it measures decision-making involving cost-benefit analysis and direct feedback regarding decision outcomes, correct?
Yes.
And he scored in the high average range, right?
You did.
And that's just 9 months after the crimes that were committed here, fair?
Yes.
Now, you also did social cognition and emotional intelligence back in April of 2013. Is that true?
Yes.
But not in January of 2015, fair?
Right.
One of the things that you check for, and you've sort of told us about this, is you check to see if he is able to discern in others, either by appearance or by sound, their emotional state, correct?
Yes.
And there's nothing in his testing here that would indicate he lacked the ability to appreciate when someone was frightened, correct?
That's true.
And really, your report doesn't really even come to any conclusions other than to tell us how he did on the tests. You'd agree with that, the April 2013. Correct?
Correct.
Okay. So in between April, by the way, you give your report over to Mr. King, and then do you think that's it at that point for you on this case in terms of the neuropsychological testing?
I probably didn't think about it in that manner, but I did think that I've completed my job. In this case, I may be asked to consult at some point in the future. That would be not an unusual expectation, but yes, that's what I thought at the time.
But to be clear, you made no plans to do that important second round of testing that Mr. King asked you about, fair?
Not at that time, no.
So when you left after this testing, you thought, I've done my job, I've done what I've been asked, that's it, fair?
Fair.
Now you are contacted again by Mr. King or the defense, it doesn't have to be Mr. King, anyone from the defense team, to again do another set of evaluations. Do you recall that?
I recall having a conversation about that idea, yes.
When was that conversation?
Sometime in the fall of 2014.
Sometime in the fall in 2014. And then what you end up doing is scheduling time to do this 2 weeks before jury selection starts in this case. Is that fair?
Yes.
In fact, you don't even issue your report until after we're already in jury selection, correct?
I'm not necessarily aware of that, but if that's the timing of it, I accept it.
How about this? You issued your report to the defense on January 31st, 2015.
Correct.
And by then, by the time of that testing that you reported on January 31st, from January 5th and 6th, the defendant had undergone even more psychological testing than he had when we were talking about July 2014, correct? Well, he had the SIRS 2 from Dr. Gray, fair?
Yes.
And whatever additional follow-up MMPI-2 and PAI, correct?
Okay, I misunderstood the question, but yes,
And
exactly.
he'd also had a full-on interview, psychiatric interview that we watched for 22 hours with Dr. Reed, correct?
Right.
And there's no reason to think he wasn't completely aware of the issues at hand regarding his mental health when you sit down with him on January 5th, 2015, right?
True.
Now, by the time you sit down, I'm sorry, Aaron, if I could have a moment.
Yes?
Well, here's what I was looking for. You were actually given, at least in your report, you described being given the exact same instructions by the defense to conduct an objective assessment of interval change. This is new, interval change with respect to the neuropsychological status. Is that fair?
Yes.
All right. So you set out by doing some of the same tests that you did before, but not all of them.
Correct.
And one of the ones we know you didn't do is social cognition, right?
Right.
You had some additional records to review. Is that fair?
I did.
And those records do not seem to include anything from a Jonathan Woodcock, correct?
Correct.
And they don't include some of the other stuff we've talked about, emails, texts, G-chats, none of that stuff?
Right.
So is it fair to say if you didn't include them, you sure didn't consider them?
True.
Does that mean you weren't provided them?
No.
Were you provided them?
I was provided some of them.
How about the notebook?
I was provided with the notebook.
Did you review that prior to your second interview of the defendant?
I did.
And did you end up inquiring of him about that?
No.
I'll be honest, I'm looking at your records reviewed here on page 3. I don't see the notebook. Is it on there?
It is not on there.
Okay. Just a mistake though, right? I mean, you did review it. You would have put it on there. It just slipped through the cracks, fair?
It is. It wasn't something that I was going to document in my report, but I was aware of it and I had reviewed it.
Okay, thank you. Once again then, we go through a series of questions that you asked the defendant, correct?
Yes.
And this is where you ask him about the books that he's reading, right?
Yes.
Why is that important to you?
Because I was interested in how he was spending his time.
And he tells you he's reading some books called The Best of Enemies, Trouble in Mind, and American Assassin. Is that fair?
Correct.
You make some more behavioral observations of him, don't you?
Yes.
And those include almost the same things you observed before back in April of 2013, true?
Essentially.
Including his eye contact and conversational turn-taking were within normal limits.
Right.
All right. And then we get into the testing that you did with him, right?
Yes.
This testing is significant on your testimony because what you've said is, look, the difference in his full-scale IQ and some of the subtests that we'll talk about, that means something to me about his potential mental health. Fair?
Yes.
Well, let's talk about that test. One of the things that you did when you wrote your report was you said his test results in April 2013 was 123, full scale, and in January of 2015, it was 116. Is that right?
Right.
And when you wrote your report, I should ask you this. Forgive me, I'm going to back up. Do you do it like the other psychologists, psychiatrists, and use a computer system or software to do all the special numbers and stuff? To score it and stuff?
Well, in some tests in which there are computer programs to score, most of the neuropsychological tests, you have to score by hand. You can then enter those scores that you have scored by hand into a computer program that generates a nice, clean report that of data that you've already calculated.
Is it that software then that calculates the practice effect?
Yes.
And is that what you use to help calculate your practice effect?
Yes.
Now, in this particular case, what you know about that software is that the practice effect is time limited on that software, isn't it?
It is.
And in fact, it doesn't allow you to use a formula earlier than 8 days, correct?
Right.
Nor later than 82 days, correct?
Right.
And when we're talking practice effect, we're talking about the ability of someone to perform better on a test that they have recently seen before, correctly?
Yes.
That was a horrible word, correct?
Yes.
Thank you. And this software that calculates this does not take into consideration day 83 and beyond, correct?
That's right.
Tell us, how many days after that first WACE-4, that first IQ test, did you administer the second IQ test?
Well, it's 20 months, so that's approximately 600 days.
600 days.
Yes.
And that software does not calculate for that, does it?
That program does not specifically calculate for that.
But you included that calculation in your report, didn't you?
I did.
That's an error, isn't it?
I think it's reasonable for someone to interpret that as an error. I don't agree that it's an error because of what we know about the duration of practice effects on the Wechsler Adult Intelligence Scale and the Wechsler Memory Scale.
And I want to be clear that the software itself makes a distinction between how it calculates the results at 8 days and 82 days and in between, correct?
Yes.
It's fair for us to conclude then that if someone were to take that test 7 times 82 later, that practice effect would even be more diminished than it was at 82 days, correct?
I'm not sure I understand the question. So if you take it repeatedly 7 times?
No, so I'm sorry. I use 7 times as a multiplier by 82. What I should have said is someone that retakes a test 600 days later, not 82, the max by the software. We would expect that the practice effect would even be more diminished 600 days later than 82 days later, right?
That's reasonable.
So, and because that's reasonable, it's also reasonable for us to conclude that you putting in the data from day 82 was not an accurate representation of the practice effect at day 600 for that guy, right?
That's a reasonable conclusion.
I want to talk to you about that difference too, because that really seems to be, in fact, it looks like his decrease, frankly, his statistically significant decrease in his neuropsychological testing is really in this full-scale IQ and the subtests. Fair?
Yes.
I mean, other areas he goes up a little, he goes down a little bit. In terms of statistical significance, something that you relied upon in giving your opinion about it being part of that schizophrenia spectrum disorder. Do you remember that?
Yes.
This is really the big piece of evidence for you, isn't it?
It is.
Okay, let's talk about the full-scale IQ testing. The biggest piece of that in terms of changing it from 123 to 116, raw scores, was the PRI, right?
It was.
And the PRI is comprised of 3 tests, isn't it?
Yes.
And those 3 tests include block design,
Yes.
matrix reasoning, and visual puzzles.
Correct.
Those tests are not all scored the same, are they?
No.
And
Well, they're scored. They're
it's too vague. Forgive me. I'll ask you a better question. Some of those tests are scored based on accuracy alone, like matrix reasoning.
right.
The other 2 tests are based on a combination of time and accuracy. Fair?
Yes. Yes. Sorry.
That's okay. That's okay. The 2 tests that he had the biggest fluctuations in, if at all, were the ones related to time, correct?
Correct.
In fact, he showed virtually no change in just the accuracy of the matrix reasoning.
Correct. Just 1 point.
The way that these things get scored is based on a cutoff of time, isn't it?
Yes.
So there are a number of, let's take block
Design.
block design, thank you. Let's take block design. How many block designs are there? Like 15 or more? Is that too big?
Is it okay if I-
Please check. I want to be right, please.
The block design subtest is comprised of 14 items.
14 items. And there's time limits on each of those, right?
Yes.
And again, just for the record, you're looking at something. What is it?
This is the protocol for the administration of the block design subtest.
Is it the actual one that the defendant did? Or is that just like an instruction sheet?
This is the one he did.
Okay. Now, one of the things in terms of scoring that is the time limits change depending upon how complicated the puzzle is. Fair?
True.
And if you go over the time limit by 1 second, do you get any points?
No.
How many points do you get, and just give us a sampling, how many points do you get if you make it within the time limit?
If you make it within the time limit, well, for some of the items, if you make it within time limit, you get, it's just a maximum of 4 points.
And some of them, you get bonus points for being super fast, right?
True.
And if you fall below the cutoff for super fast, you get less points, correct?
Right.
What's the maximum amount of time that you can get for any one of the puzzles?
Maximum amount of time is 2 minutes.
2 minutes. How many points do you get if you complete that puzzle within 2 minutes?
4 points.
How many points do you get if you complete it within 2 minutes and 1 second?
None.
Is it accurate to say that someone could take that test twice over 20 months, get every single puzzle exactly right both times, but they're slower by a couple seconds here and there, and it drastically changes their score?
That is possible.
Now let's talk about the, what was the third test, sir? It was the visual puzzles.
Right.
Now, is visual puzzles scored the same way or different?
It is scored differently.
Does it involve time?
Yes.
Can you tell us how time works with the scoring on the visual puzzles?
Time on the visual puzzles, there's not a gradient of time that determines score. So there isn't a, say, on the items from the block design, the more difficult items where it can be 4 points, 5 points, 6 points, 7 points. That's not the case on visual puzzles. Visual puzzles is all or nothing. You have a cutoff time. If you get it right within that cutoff time, you get the point. If you don't get it right within the cutoff time, you don't get the point.
What kind of cutoff time are we talking about?
30 seconds.
Fair to say again that someone who on April of 2013 were getting these things 100% correct at 29 seconds would get the point, and 20 months later getting them at 31 seconds would not get the point.
That's
Fair?
true.
Those two tests, if you slowed down by a couple seconds on a handful of these items, could throw off your PRI score pretty significantly.
Object to throw off the PRI score. This score would be accurate still.
Overruled. I understood the question. Did you understand the question, Doctor?
I think so.
That's right, isn't it?
It could change it, yes.
And if that PRI is changed enough because of those handful of seconds here and there on the different puzzles, that could impact your full-scale IQ, correct?
Yes.
Let's talk about some things that might impact the speed, the psychomotor speed with which someone might do these tests, okay?
Okay.
At the time the defendant takes this battery of tests in January of 2015, he has been incarcerated in relative isolation for 899 days. Is that correct?
I believe you.
Okay. Thank you. I should have said a bigger number, but I think it is 899. The other thing that we know about psychomotor speed is that it can be impacted by depression, correct?
True.
And this guy's depressed, right?
He is. He was particularly depressed when I saw him in 2013.
Still depressed in 2015, right?
I think he was still depressed. He reported being significantly less depressed to me in 2015 relative to 2013, but he still reported depression.
Not only that, but stress. My gosh, stress can impact how someone performs on any test, couldn't it?
It can.
And in this particular case, you administered these time-sensitive tests 2 weeks before jury selection was to begin on a case that might result in a death sentence for him, correct?
True.
Can I have a moment, Your Honor?
You can.
Doctor, one other area I wanted to get into with you, and I should have done it when we were talking about the malingering. You remember on your PowerPoint slide up here, you had all those validity malingering tests, correct?
Yes.
And at the bottom, you had listed both his performance on the August 2013 MMPI-2 and PAI, as well as the they did it again in July 2014 MMPI-2 and PAI, correct?
Right.
And you thought the outcomes of those things were significant, right?
Yes.
Okay, now one of the things though we've already talked about is those malingering validity tests don't guarantee us honesty, accuracy, or forthcoming answers from the defendant. Do you agree with that?
Asked and answered, Your Honor.
Overruled.
Yes? You agree?
Yes.
Now, you know that the MMPI-2 is made up of 567 questions, correct?
Yes.
And those questions include topic areas like that touch on hallucinations, yes?
Yes.
And both visual and audio, right?
Yes.
Whether or not someone's feeling suicidal, correct?
Yes.
Objection, this is beyond the scope of direct examination.
Would counsel approach, please? Members of the jury, rather than keep you waiting, let's go ahead and take a break. It's about time for the afternoon break anyhow. And one of you suggested it, and I think it's a good suggestion. So I'm going to go along with the suggestion, but I'm making it sound like it's my idea. So please make sure you keep all my admonishments in mind during the break. Enjoy the break, and we'll see you back here in about 20 minutes or so, all right? Thank you. The record should reflect that the jury has exited the courtroom. Let's go ahead and take our afternoon break, and then I'll chat with counsel after the break. The court will be in recess. Thank you.
Please rise.